Welcome once again to Know Your Rights University in association with Natural Essence Compact LLC. We are back at you once again with another video that we hope will be of benefit to you. And let us begin by sharing our screen. We're going to be reading from some case law today. The title of this video, once again, is called What You Own Can Be Taken. Let us share our screen. As you can see, this is a United States Supreme Court case we're going to be reading from called Dreyer versus United States. But before we get into that, we would like to just say that what you have can be taken. What you own can be taken, whether it be through lawsuits, probate, taxes, or seizure. These are not rare misfortunes, they are systematic outcomes. They are baked into the public ownership model. When your home, business, bank account, or investments are titled in your personal name, you invite exposure to litigation, to IRS scrutiny, to creditor garnishment, and to probate intervention. Your name on title equals your name on a target list. Now let us begin reading the case. Once again, the case is called Dry et al. Versus United States. Justice Ginsburg delivered the opinion of the court. This case concerns the respective provinces of state and federal law in determining what is property for purposes of federal tax lien legislation. At the time of his mother's death, petitioner Ron F. Dry Jr. was insolvent and owed the federal government some $325,000 on unpaid tax assessments for which notices of federal tax liens have been filed. His mother died intestate, leaving an estate with a total value of approximately $233,000 to which he was sole heir. So his mother died without a will or some sort of entity like a trust to pass on wealth to chosen heirs. After the passage of several months, Dry disclaimed his interest in his mother's estate, which then passed by operation of state law to his daughter. This case presents the question whether Dry's interest as heir to his mother's estate constituted property or a right to property to which the federal tax liens attached under 26 U.S.C. Section 6321, despite Dry's exercise of the prerogative state law accorded him to disclaim the interests retroactively. We hold that the disclaimer did not defeat the federal tax liens. The Internal Revenue Code's prescriptions are most sensibly read to look to state law for delineation of the taxpayer's rights or interests, but to leave to federal law the determination whether those rights or interests constitute property or rights to property within the meaning of Section 6321. Once it has been determined that state law creates sufficient interest in the taxpayer to satisfy the requirements of the federal tax lien provision, state law is inoperative to prevent the attachment of liens created by federal statutes in favor of the United States. United States versus Best. The relevant facts are not in dispute. On August 3rd, 1994, Irma Delilah Dry died intestate, leaving an estate worth approximately $233,000, of which $158,000 was personalty and $75,000 was realty, located in Pulaski County, Arkansas. Petitioner Ron F. Dry Jr., her son, was sole heir to the estate under Arkansas law. See Arkansas Code annotated section 28-9-214, 1987. Intestate interest passes first to the children of the estate. On the date of his mother's death, Dry was insolvent and owed the government approximately $325,000, representing for tax deficiencies in years 1988, 1989, and 1990. The Internal Revenue Service, IRS, orders had made assessments against Dry in November 1990 and May 1991 and had valid tax liens against all of Dry's property and rights to property pursuant to 26 U.S.C. Section 6321. Dry petitioned the Pulaski County Probate Court for appointment as administrator of his mother's estate and was appointed on August 17, 1994. Almost 6 months later, on February the 6th, 1995, Dry filed in the probate court and land records of Pulaski County a written disclaimer of all interests in his mother's estate. 2 days later, Dry resigned as administrator of the estate. Under Arkansas law, an heir may disavow his inheritance by filing a written disclaimer no later than 9 months after the death of the decedent. The disclaimer creates the legal fiction that the disclaimant predeceased the decedent. Consequently, the disclaimer's share of the estate passes to the person next in line to receive that share. The disavowing heirs, creditors, Arkansas law provides, may not reach property thus disclaimed. In the case at hand, Dry's disclaimer caused the estate to pass to his daughter, Teresa Dry, who succeeded her father as administrator and promptly established the Dry Family 1995 Trust. On March 10, 1995, the probate court declared valid Dry's disclaimer of all interest in his mother's estate and accordingly ordered final disposition of the estate to Teresa Dry. Teresa Dry then used the estate's proceeds to fund the trust, of which she and, during their lifetimes, her parents and the beneficiaries, are the beneficiaries. Under the trust terms, distributions are at the discretion of the trustee. Dry's counsel, Daniel M. Traylor, and may be made only for the health, maintenance, and support of the beneficiaries. The trust is spendthrift, and under state law, its assets are therefore shielded from creditors seeking to satisfy the debts of the trust's beneficiaries. Also in 1995, the IRS and Dry began negotiations regarding Dry's tax liabilities. During the course of the negotiations, Dry revealed to the service his beneficial interest in the trust. Thereafter, on April 11, 1996, the IRS filed with the Pulaski County Circuit Clerk and Recorder a notice of federal tax lien against the trust as Dry's nominee. The service also served a notice of levy on accounts held in the trust's name by an investment bank and notified the trust of the levy. On May 1st, 1996, invoking 26 U.S.C. 7426A1, the trust filed a wrongful levy action against the United States in the United States District Court for the Eastern District of Arkansas. The government counterclaimed against the trust, the trustee, and the trust beneficiary, seeking to reduce to judgment the tax assessments against Dry, confirm its rights to seize the trust assets and collection of those debts, foreclose on its liens, and sell the trust property. On cross motions for summary judgment, the district court ruled in the government's favor. The United States Court of Appeals for the Eighth Circuit affirmed the district court's judgment. The Court of Appeals understood our precedents to convey that state law determines whether a given set of circumstances creates a right or interest. Federal law then dictates whether that right or interest constitutes property or the right to property under Section 6321. We granted certiorari to resolve a conflict between the Eighth Circuit's holding and decisions of the Fifth and Ninth Circuits. We now affirm, under the relevant provisions of the Internal Revenue Code, to satisfy a tax deficiency, the government may impose a lien on any property or rights to property belonging to the taxpayer. Section 6321 provides if any person liable to pay any tax neglects or refuses to pay the same after demand, the amount shall be a lien in favor of the United States upon all property and rights to property, whether real or personal, belonging to such person. 26 U.S.C. Section 6321. A complementary provision, Section 6331A, states, if any person liable to pay any tax neglects or refuses to pay the same within 10 days after notice and demand, it shall be lawful for the Secretary to collect such tax by levy upon all property and rights to property, except such property as is exempt under Section 6334 belonging to such person or on which there is a lien provided in this chapter for the payment of such tax. The language in Sections 6321 and 6331A, this court has observed, is broad and reveals on its face that Congress meant to reach every interest in property that a taxpayer might have. United States versus National Bank of Commerce, citing 4B, Bitker, Federal Taxation of Income, Estates, and Gifts. See also Glass City Bank versus United States, which held stronger language could hardly have been selected to reveal a purpose to assure the collection of taxes. When Congress so broadly uses the term property, we recognize, as we did in the context of the gift tax, that the legislature aims to reach every species of right or interest protected by law and having an exchangeable value. Section 6334A of the Code is corroborative. That provision lists property exempt from levy. The list includes 13 categories of items. Among the enumerated exemptions are certain items necessary to clothe and care for one's family, unemployment compensation, and workers' compensation benefits. Sections 6334A1, 2, 4, and 7. The enumeration contained in Section 6334A, Congress directed, is exclusive. Notwithstanding any other laws of the United States, no property or rights to property shall be exempt from levy other than the property specifically made exempt by subsection A, 6334C. Inheritance or devices disclaimed under state law are not included in Section 633A's catalog of property exempt from levy. See best. The fact that Congress provided specific exemptions from distraint is evidence that Congress did not intend to recognize further exemptions which would prevent attachment of federal tax liens. United States versus Mitchell. The language of Section 6334 is specific and it is clear, and there is no room in it for automatic exemption of property that happens to be exempt from state levy under state law. The absence of any recognition of disclaimers in Section 6321, 6322, 6331A, and 6334A and C, the relevant tax collection provisions contrast with Section 2518A of the Code, which renders qualifying state law disclaimers with respect to any interest in property effective for federal wealth transfer tax purposes and for those purposes only. Dry nevertheless refers to cases indicating that state law is the proper guide to the critical determination whether his interest in his mother's estate constituted property or rights to property. Under Section 6321, his position draws support from two recent appellate opinions, Leggett versus United States, where it said Section 6321 adopts the state's definition of property interest, and Mapes versus United States, where it was said for the answer to the question whether taxpayer had the requisite interest in property, we must look to state law, not federal law. Although our decisions in point have not been phrased so meticulously as to provide Dry's argument, we are satisfied that the code and interpretive case law placed under federal, not state, control the ultimate issue of whether a taxpayer has a beneficial interest in any property subject to levy for unpaid federal taxes. As stated in National Bank of Commerce, the question whether a state law right constitutes property or rights to property is a matter of federal law. We look initially to state law to determine what rights the taxpayer has in the property the government seeks to reach, then to federal law to determine whether the taxpayer's state delineated rights qualify as property or rights to property within the compass of the federal tax lien legislation. Morgan versus Commissioner, where it was held state law creates legal interests and rights. The Federal Revenue Act designate what interests or rights so created shall be taxed. In line with this division of competence, we held that a taxpayer's right under state law to withdraw the whole of the proceeds from a joint bank account constitutes property or the right to property subject to levy for unpaid federal taxes, although state law would not allow ordinary creditors similarly to deplete the account. National Bank of Commerce. And we earlier held that a taxpayer's right under a life insurance policy to compel his insurer to pay him the cash surrender value qualifies as property or a right to property subject to attachment for unpaid federal taxes, although state law shielded the case surrender value from creditors' liens. Best. By contrast, we also concluded, again, as a matter of federal law, that no federal tax lien could attach to policy proceeds unavailable to the insured in his lifetime. It would be anomalous to view as property subject to lien proceeds never within the insured's reach to enjoy. Just as exempt status under state law does not bind the federal collector, so federal tax law is not struck blind by a disclaimer. Thus, in Mitchell, the court held that although a wife's renunciation of a marital interest was treated as retroactive under state law, that state law disclaimer did not determine the wife's liability for federal tax on her share of the community income realized before the renunciation. See 403 U.S. at 204, where it was said right to renounce does not indicate that taxpayer never had a right to property. The Eighth Circuit, with fidelity to the relevant code provisions and our case law, determined first what rights state law accorded Dry in his mother's estate. It is beyond debate. The Court of Appeals observed that under Arkansas law, Dry had at his mother's death a valuable transferable, legally protected right to the property at issue. C 152, Federal Reporter 3D at 895. Although code does not define property or rights to property, appellate courts read those terms to encompass state law rights or interests that have pecuniary value and are transferable. The court noted, for example, that a prospective heir may effectively assign his expectancy in an estate under Arkansas law, and the assignment will be enforced when the expectancy ripens into a present estate. Citing several Arkansas Supreme Court decisions, including these cases here, Dry emphasizes his undoubted right under Arkansas law to disclaim the inheritance. See Arkansas Code Annotated, Section 28-2-101, a right that is indeed personal and not marketable. See Brief for Petitioners 13, right to disclaim is not transferable and has no pecuniary value. But Arkansas law primarily gave Dry a right of considerable value, the right either to inherit or to channel the inheritance to a close family member, the next lineal descendant. The right simply cannot be written off as a mere personal right to accept or reject a gift. In pressing the analogy to a rejected gift, Dry overlooks this crucial distinction. A donee who declines an inter vivos gift generally restores the status quo ante, leaving the donor to do with the gift what she will. The disclaiming heir or devisee, in contrast, does not restore the status quo, for the decedent cannot be revived. Thus, the heir inevitably exercises dominion over the property. He determines who will receive the property, himself if he does not disclaim, a known other if he does. See Hirsch, The Problem of the Insolvent Heir. This power to channel the estate's assets warrants the conclusion that Dry held property or right to property subject to the government's liens. In sum, in determining whether a federal taxpayer's state law rights constitute property or rights to property, the important consideration is the breadth of the control the taxpayer could exercise over the property. Morgan. Dry had the unqualified right to receive the entire value of his mother's estate, less administrative expenses. See National Bank of Commerce, confirming that unqualified right to receive property is itself a property right subject to the tax collector's levy or to channel that value to his daughter. The control reign he held under state law, we hold, rendered the inheritance, property, or rights to property belonging to him within the meaning of Section 6321 and hence subject to the federal tax liens that sparked this controversy. For the reasons stated, the judgment of the Court of Appeals for the Eighth Circuit is affirmed. And there you have it. Although he attempted to utilize state law to evade or maybe what he thought in his mind avoid the tax deficiency that had been assessed against him and to pass on his rights to property inherited from his mother's estate to his daughter, the federal statute or federal law or federal code said that no, 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 we're not going to have you to pass on any inheritance where we have already assessed against you a tax liability. So therefore, what you own can be taken. We thank you once again for listening to Know Your Rights University in association with Natural Lessons Compact LLC. We hope this information has been a benefit to you. And we like to say before we go that we believe that had this person, or should we say the mom, structured her estate properly through means of an entity such as a private trust, maybe all of this unfortunate loss could have been avoided, and her children's children could have received the inheritance that was due to her. Once again, we thank you. Until next time, peace and blessings to you all.